Birchfield v. North Dakota, Supreme Court, 2016. Justice Alito delivered the opinion of the court. Drunk drivers take a grisly toll on the nation's roads, claiming thousands of lives, injuring many more victims, and inflicting billions of dollars in property damage every year. To fight this problem, all states have laws that prohibit motorists from driving with a blood alcohol concentration that exceeds a specified level. But determining whether a driver's BAC is over the legal limit requires a test, and many drivers stopped on suspicion of drunk driving would not submit to testing if given the option. So every state also has long had what are termed implied consent laws. These laws impose penalties on motorists who refuse to undergo testing when there is sufficient reason to believe that they are violating the state's drunk driving laws. In the past, the typical penalty for noncompliance was suspension or revocation of the motorist's license. The cases now before us involve laws that go beyond that and make it a crime for a motorist to refuse to be tested after being lawfully arrested for driving while impaired. The question presented is whether such laws violate the Fourth Amendment's prohibition against unreasonable searches. 1. The most common and economical method of calculating BIC is by means of a machine that measures the amount of alcohol in a person's breath. Today, such devices can detect the presence of alcohol more quickly and accurately than before, typically using infrared technology rather than a chemical reaction. In practice, all breath testing machines used for evidentiary purposes must be approved by the National Highway Traffic Safety Administration. These machines are generally regarded as very reliable because the federal standards require that the devices produce accurate and reproducible test results at a variety of BAC levels from the very low to the very high. Measurement of a BAC based on a breath test requires the cooperation of the person being tested. The subject must take a deep breath and exhale through a mouthpiece that connects to the machine. Typically, the test subject must blow the air into the device for a period of several seconds to produce an adequate breath sample, and the process is sometimes repeated so that analysts can compare multiple samples to ensure the device's accuracy. Modern breath test machines are designed to capture so-called deep lung or alveolar air. Air from the alveolar region of the lungs provides the best basis for determining the test subject's BAC, for it is in that part of the lungs that alcohol vapor and other gases are exchanged between blood and breath. When a standard infrared device is used, the whole process takes only a few minutes from start to finish. Most evidentiary breath tests do not occur next to the vehicle at the side of the road, but in a police station, where the controlled environment is especially conducive to reliable testing, or in some cases in the officer's patrol vehicle or in special mobile testing facilities. Because the cooperation of the test subject is necessary when a breath test is administered, and highly preferable when a blood sample is taken, the enactment of laws defining intoxication based on BAC made it necessary for states to find a way of securing such cooperation. So-called implied consent laws were enacted to achieve this result. They provide that cooperation with BAC testing was a condition of the privilege of driving on state roads, and that the privilege would be rescinded if a suspected drunk driver refused to honor that condition. Suspension or revocation of the motorist's driver's license remains the standard legal consequence of refusal. In addition, evidence of the motorist's refusal is admitted as evidence of likely intoxication in a drunk driving prosecution. In recent decades, the states and federal government have toughened drunk driving laws, and those efforts have corresponded to a dramatic decrease in alcohol-related fatalities. As of the early 1980s, the number of annual fatalities averaged 25,000. By 2014, the most recent year for which statistics are available, the number had fallen to below 10,000. One legal change has been further lowering the BAC standard from 0.1 to 0.08. In addition, many states now impose increased penalties for recidivists and for drivers with BAC levels that exceed a higher threshold. Many other states have taken a similar approach, but this new structure threatened to undermine the effectiveness of implied consent laws. If the penalty for driving with a greatly elevated BAC or for repeat violation exceeds the penalty for refusing to submit to testing, motorists who fear conviction for the more severely punished offense have an incentive to reject testing, and in some states the refusal rate is high. On average, over 1/5 of all drivers asked to submit to a BAC testing in 2011 refused to do so. To combat the problem of test refusal, some states have begun to enact laws making it a crime to refuse to undergo testing. 2. Petitioner Danny Birchfield accidentally drove his car off a North Dakota highway on October 10, 2013. A state trooper arrived and watched as Birchfield unsuccessfully tried to drive back out of the ditch in which his car was stuck. The trooper approached, caught a strong whiff of alcohol, and saw that Birchfield's eyes were bloodshot and watery. Birchfield spoke in slurred speech and struggled to stay steady on his feet. At the trooper's request, Birchfield agreed to take several field sobriety tests and perform poorly on each. He had trouble reciting sections of the alphabet and counting backwards in compliance with the trooper's directions. The state trooper arrested Birchfield for driving while impaired, gave the usual Miranda warnings, again advised him of his obligation under North Dakota law to undergo BAC testing, and informed him, as state law requires, that refusing to take the test would expose him to criminal penalties. Although faced with the prospect of prosecution under this law, Birchfield refused to let his blood be drawn. On August 5, 2012, Minnesota police received a report of a problem at a South St. Paul boat launch. 3 apparently intoxicated men had gotten their truck stuck in the river while attempting to pull the boat out of the water. When police arrived, witnesses informed them that a man in underwear had been driving the truck. That man proved to be William Robert Bernard Jr., petitioner in the second of these cases. Bernard admitted that he had been drinking, but denied driving the truck, though he was holding its keys, and refused to perform any field sobriety tests. After noting that Bernard's breath smelled of alcohol and that his eyes were bloodshot and watery, officers arrested Bernard for driving while impaired. Back at the police station, officers read Bernard Minnesota's Implied Consent Advisory, which, like North Dakota's, informs motorists that it is a crime under state law to refuse to submit to a legally required BAC test. The officers asked Bernard to take a breath test. After he refused, prosecutors charged him with test refusal in the first degree because he had 4 prior impaired driving convictions. A police officer spotted our third petitioner, Steve Michael Bayland, driving the streets of Bowman, North Dakota, on the night of August 10, 2013. The officer saw Bayland try unsuccessfully to turn into a driveway. In the process, Bayland's car nearly hit a stop sign before coming to a stop still partly on the public road. The officer walked up to the car and saw that Bayland had an empty wine glass in the center console next to him. Noticing that Bayland also smelled of alcohol, the officer asked him to step out of the car. As Bayland did so, he struggled to keep his balance. The officer arrested Bayland for driving while impaired and took him to a nearby hospital. There, he read Bayland North Dakota's Implied Consent Advisory, informing him that the test refusal in these circumstances is itself a crime. Unlike the other 2 petitioners in these cases, Bayland agreed to have his blood drawn and analyzed. A nurse took a blood sample, which revealed a blood alcohol concentration of 0.25, more than 3 times the legal limit. Given the test results, Bayland's driver's license was suspended for 2 years after an administrative hearing. Bayland appealed the hearing officer's decision to a North Dakota district court, principally arguing that his consent to the blood test was coerced by the officer's warning that refusing to consent would itself be a crime. 3. As our summary of the facts and proceedings in these cases reveals, the cases differ in some respects. Petitioners Birchfield and Bayland were told that they were obligated to submit to a blood test, whereas petitioner Bernard was informed that a breath test was required. Despite these differences, success for all 3 petitioners depends on the proposition that the criminal law ordinarily may not compel a motorist to submit to the taking of a blood sample or to a breath test unless a warrant authorizing such testing is issued by a magistrate. If, on the other hand, such warrantless searches comport with the Fourth Amendment, it follows that a state may criminalize the refusal to comply with a demand to submit to the required testing, just as a state may make it a crime for a person to obstruct the execution of a valid search warrant. 4. The Fourth Amendment prohibits unreasonable searches, and our cases establish that the taking of blood samples or the administration of a breath test is a search. The question then is whether the warrantless searches at issue here were reasonable. In the 3 cases now before us, the drivers were searched or told that they were required to submit to a search after being placed under arrest for drunk driving. We therefore consider how the search incident to arrest doctrine applies to breath and blood tests incident to such arrests. 5. We begin by considering the impact of breath and blood tests on individual privacy interests, and we will discuss each type of test in turn. Subsection 1. Years ago, we said that breath tests do not implicate significant privacy concerns. That remains so today. First, the physical intrusion is almost negligible. Breath tests do not require piercing the skin and entail a minimum of inconvenience. As Minnesota describes its version of the breath test, the process requires the arrestee to blow continuously for 4 to 15 seconds into a straw-like mouthpiece that is connected by a tube to the test machine. The effort is no more demanding than blowing up a party balloon. Petitioner Bernard argues, however, that the process is nevertheless a significant intrusion because the arrestee must insert the mouthpiece of the machine into his or her mouth. But there is nothing painful or strange about this requirement. The use of a straw to drink beverages is a common practice and one to which few object. Nor, contrary to Bernard, is the test a significant intrusion because it does not capture an ordinary exhalation, the kind that routinely is exposed to the public, but instead requires a sample of alveolar deep lung air. Humans have been known to assert a possessory interest in or an emotional attachment to any of the air in their lungs. The air that humans exhale is not part of their bodies. Exhalation is a natural process, indeed one that is necessary for life. Humans cannot hold their breath for more than a few minutes, and all the air that is breathed into a breath-analyzing machine, including deep lung air, sooner or later would be exhaled even without the test. Second, breath tests are capable of revealing only one bit of information, the amount of alcohol in the subject's blood. A breath test results in a BAC reading on a machine, nothing more. No sample of anything is left in the possession of the police. Finally, participation in a breath test is not an experience that is likely to cause any great enhancement in the embarrassment that is inherent in any arrest. The act of blowing into a straw is not inherently embarrassing, nor are evidentiary breath tests administered in a manner that causes embarrassment. Again, such tests are normally administered in private at a police station, in a patrol car, or in a mobile testing facility, out of public view. Moreover, once placed under arrest, the individual's expectation of privacy is necessarily diminished. For all these reasons, a breath test does not implicate significant privacy concerns. Subsection 2. Blood tests are a different matter. They require piercing the skin and extract a part of the subject's body. And while humans exhale air from their lungs many times per minute, humans do not continually shed blood. It is true, of course, that people voluntarily submit to the taking of blood samples as part of physical examination, and the process involves little pain or risk. Nonetheless, for many, the process is not one they relish. It is significantly more intrusive than blowing into a tube. In addition, a blood test, unlike a breath test, places in the hands of law enforcement authorities a sample that can be preserved and from which it is possible to extract information beyond a simple BAC reading. Even if the law enforcement agency is precluded from testing the blood for any purpose other than to measure BAC, the potential remains and may result in anxiety for the person tested. Subsection C. Having assessed the impact of breath and blood testing on privacy interests, we now look to the state's asserted need to obtain BAC readings for persons arrested for drunk driving. The states and the federal government have a paramount interest in preserving the safety of public highways. Although the number of deaths and injuries caused by motor vehicle accidents has declined over the years, the statistics are still staggering. Alcohol consumption is a leading cause of traffic fatalities and injuries. During the past decade, annual fatalities in drunk driving accidents ranged from 13,582 deaths in 2005 to 9,865 deaths in 2011. The most recent data report a total of 9,969 fatalities in 2014, on average one death every 53 minutes. Justice Sotomayor's partial dissent suggests that states' interests in fighting drunk driving are satisfied once suspected drunk drivers are arrested, since such arrests take intoxicated drivers off the roads where they might do harm. But of course, states are not solely concerned with neutralizing the threat posed by a drunk driver who has already gotten behind the wheel. They also have a compelling interest in creating effective deterrents to drunken driving, so such individuals make responsible decisions and do not become a threat to others in the first place. Petitioners and Justice Sotomayor next suggest that requiring a warrant for BAC testing in every case in which a motorist is arrested for drunk driving would not impose any great burden on police or the courts. But of course, the same argument could be made about searching through objects found on the arrestee's possession, which our cases permit even in the absence of a warrant. What about the cigarette package in Robinson? What if a motorist arrested for drunk driving has a flask in his pocket? What if a motorist arrested for driving while under the influence of marijuana has what appears to be a marijuana cigarette on his person? What about an unmarked bottle of pills? If a search warrant were required for every search incident to arrest that does not involve exigent circumstances, the courts would be swamped. And even if we arbitrarily singled out BAC tests incident to arrest for this special treatment, as it appears the dissent would do, the impact on the courts would be considerable. The number of arrests every year for driving under the influence is enormous, more than 1.1 million in 2014. Particularly in sparsely populated areas, it would be no small task for courts to field a large new influx of warrant applications that could come on any day of the year and at any hour. In many jurisdictions, judicial officers have the authority to issue warrants only within their own districts, and in rural areas, some districts may have only a small number of judicial officers. Having assessed the effect of BAC tests on privacy interests and the need for such tests, we conclude that the Fourth Amendment permits warrantless breath tests incident to arrests for drunk driving. The impact of breath tests on privacy is slight, and the need for BAC testing is great. We reach a different conclusion with respect to blood tests. Blood tests are significantly more intrusive, and their reasonableness must be judged in light of the availability of the less invasive alternative of a breath test. Respondents have offered no satisfactory justification for demanding the more intrusive alternative without a warrant. Neither respondents nor their amici dispute the effectiveness of breath tests in measuring BAC. Breath tests have been in common use for many years. Their results are admissible in court and are widely credited by juries, and respondents do not dispute their accuracy or utility. What, then, is the justification for warrantless blood tests? One advantage of blood tests is their ability to detect not just alcohol, but also other substances that can impair a driver's ability to operate a car safely. A breath test cannot do this, but police have other measures at their disposal when they have reason to believe that a motorist may be under the influence of some other substance. For example, if a breath test indicates that a clearly impaired motorist has little, if any, alcohol in his blood. Nothing prevents the police from seeking a warrant for a blood test when there is sufficient time to do so in the particular circumstances, or from relying on the exigent circumstances exception to the warrant requirement when there is not. A blood test also requires less driver participation than a breath test. In order for a technician to take a blood sample, all that is needed is for the subject to remain still, either voluntarily or by being immobilized. Thus, it is possible to extract a blood sample from a subject who forcibly resists, but many states reasonably prefer not to take this step. It is true that a blood test, unlike a breath test, may be administered to a person who is unconscious, perhaps as a result of a crash, or who is unable to do what is needed to take a breath test due to profound intoxication or injuries. But we have no reason to believe that such situations are common in drunk driving arrests, and when they arise, the police may apply for a warrant if need be. A breath test may also be ineffective if an arrestee deliberately attempts to prevent an accurate reading by failing to blow into the tube for the requisite length of time or with the necessary force. The courts have held that such conduct qualifies as a refusal to undergo testing, and it may be prosecuted as such. And again, a warrant for a blood test may be sought. Because breath tests are significantly less intrusive than blood tests, and in most cases because breath tests are significantly less intrusive than blood tests, and in most cases amply serve law enforcement interests, we conclude that a breath test, but not a blood test, may be administered as a search incident to a lawful arrest for drunk driving. As in all cases involving reasonable searches incident to arrest, a warrant is not needed in this situation.